So now we get to the point where we talk about race and how it plays out in the jury selection and to the eventual judgment. And everyone knows the story of Emmett Till, the young African American male who in 1955 was from Chicago, but he was visiting his family in Mississippi, and he was essentially lynched for flirting with a white woman. An all-white jury found Bryant and Millam, the two men responsible for kidnapping and lynching Emmett Till. They were found not guilty by an all-white jury in Emmett Till's murder. Now, one of the particular things about the jury in the Emmett Till case is that not only did they select an all-white jury, but they actually selected whites from an area known as Tallahatchie or Tallahatchie County, and these particular whites were constantly in conflicts with local African Americans because they were constantly fighting over land and other opportunities. Now, one of the things that is peculiar about the Emmett Till case is that one of the jurors actually voted twice to convict the two white men, but on the third time around, he acquiesced to the rest of the jury to basically acquit the two white men and set them free for the murder and lynching of Emmett Till. And in later interviews, the jurors acknowledged that they knew Bryant and Millam were actually guilty, but simply they didn't believe a life imprisonment or death penalty were fit punishments for white men who killed black men. Now, the funny thing about all this is that both Bryant and Millam, under the protection of double jeopardy, publicly admitted in 1956 in an interview with Look magazine that they killed Emmett Till. So you can obviously see that since 1955, jury selection has always been an issue when it comes down to race. But if you use common sense, you can probably see how this has basically always been a problem ever since that blacks have become free and emancipated. Now, this issue actually exists still today, maybe not in that strict form. And as you'll see in this next clip, where Jack McMahon basically teaches prosecutors to avoid black people.
When Taz called me up and asked me to speak on jury selection, I was thinking about it, and I said to myself, when you're talking about jury selection, that is probably the single most important part of a case. Preparation, evidence, witnesses, statements, doesn't mean anything unless you have a good jury. And I've seen more than one case, great cases, and you have a lousy jury. It doesn't make a damn bit of difference unless you have a good jury. So it is probably the single most important thing that you're going to learn to do to be a good jury lawyer, is to be able to pick good juries. And but on the other hand, it's the most important, yet it's the most unscientific. It is the most difficult to learn. It differs from case to case, and you're never going to master it. Anybody says, I can pick great juries, they're lying to you. You can't. You can do it 1,000 times, and you're going to pick people that are just not good jurors. But what it is you got to go by certain rules. It's kind of like teaching blackjack. I can teach you blackjack. I can tell you all the rules to play blackjack, and you'll know how to play blackjack. But there's going to be a certain amount of luck. In other words, you can do all the right things. You can take a hit 117 when he's got a 3 and all this thing, and you can still lose. And that's the way it is in jury selection. But the key is, just as in playing blackjack, is to stay by the rules. You know, when you're going in a down Atlantic City, the people that generally win at blackjack are the people that have certain rules, they stay by them, they continue. Some days they're going to lose. They're going to get that bad card flipped on them, and you may get that bad juror flipped on you. But over the long haul, these people playing blackjack are going to win because they stay by certain rules. And that's all I can tell you when I talk to you about this, is to play by the certain rules and don't bend them and don't change them. And if you continue with those rules throughout your career, you're going to have more success than failure, just as the blackjack player would. The case law says that the object of getting a jury is to get, and I wrote it down, I looked into cases because I had to look this up because I didn't know this was the purpose of a jury. Voir dire is to get a competent, fair, and impartial jury. Well, that's ridiculous. You're not trying to get that. Both sides are trying to get the jury most likely to do whatever they want them to do. And if you go in there, any one of you think you're going to be some noble civil libertarian and try to get jurors, well, he says he can be fair, I'll go with him. That's ridiculous. You'll lose. You'll be out of the office, you'll be doing corporate law. Because that's what will happen. You're there to win. And in order to win, and the defense is there to win too, and the only way you're going to do your best is to get jurors that are as unfair and more likely to convict than anybody else in that room. And to go with that possibility, because the defense is doing the exact same thing. So you're not like if you think that it's some noble thing, that it's some esoteric game, you're wrong and you'll lose. Like I said, you have to go in there with the idea that you want jurors who are going to be most suited to convicting this defendant. Okay? Now, what does that mean? That means that you want, as I said earlier, stable, conservative people. That's what you want. Okay, what do you do to get those type of people? Number one, I told you. You look at their married life, their background, how long they've been married, how long they've been employed. Those same things I just went through, whether they've been schooled, how long they stayed in school, all these different factors to tell you that these are stable people. Now, I'm going to tell you things that I think over the years that have come to me of doing this. And again, it's all an individual. Anybody tells you anything about trying a case and says it in dogma is wrong, because things change and it's different for every individual. But I've had fairly good success with these rules, and I think if you stay to them, you'll have fairly good success too. And that is, let's face it again, there's the blacks from the low-income areas are less likely to convict. It's just, I understand it. It's an understandable proposition. There's a resentment for law enforcement. There's a resentment for authority. And as a result, you don't want those people on your jury. And it may appear as if you're being racist or whatnot, but again, you're just being realistic. You're just trying to win the case. And the other side's doing the same thing, so to just try to be noble and esoteric is not going to work. Now, besides those questions, what else do you look for? Well, in my experience, you look for how they're dressed. That is a great indicator. If a guy who maybe the questions that you ask, you're not too sure of this guy. You know, maybe he has been a bit unemployed or has a little bit of instability in his life, but yet he comes to court in a three-piece suit. You know, his shoes are shined, and he obviously has some respect for the court, respect for law, respect for the authority that he's faced with, okay? And that is like, if that could be the factor. In other words, you're wavering on the guy, but the guy is well-dressed and he shows that respect, you're more likely to take him because of that respect for the court. And the same is true about a guy. Sometimes you see a guy who looks pretty good on the questions, and he comes in shorts and cutoffs and T-shirts and a T-shirt. And what's that say to you? That guy doesn't have a lot of respect for the law or authority. So that's not the only judge, but I'll tell you, it's a big factor. And I think that if you take middle-class people that are well-dressed, you're going to do well. I mean, it's that simple sometimes. And another thing to do, little tips too, when a jury comes in the room, the 40 people come in the room, count them. Count the blacks and whites. You want to know at every point in that case where you are. In other words, the 40 come in, you never get it just right. You don't want to look there and go, is there a black guy back there? Wait a minute, are you a black guy? No, you don't want to do that. You just look at a general estimate. Like say 40 come in, you get 25, you say it's 25-15. I mark it down on my sheet, 25-15. And then I know. And then I know how many are left, and I know where I am at all times in my jury selection process. And if you lose track, or you're not sure of what's going on, or you want to, you can always take a recess. Because a lot of times what they do is they'll like have the next group. The court officers want to set them up. Like remember in that method I told you earlier where they have, now we've picked 5, so they're going to bring 7 more in. Usually they'll have the next 7 sitting right out there in order. So you can see, you can say, I just have to go to the bathroom. You can go out and see what's left. And check out what's left. See what's, because you know you got 2 strikes left. You want to know, look, if the first 2 are going to be bad, or I'm going to have to use strikes and the next ones will be good, but if there are 2, good ones coming up, then you know you're not going to have to strike them. And it changes your philosophy and your ability to make a decision knowing what's coming up. If you're just sitting there hoping and praying the next one that comes in the room is going to be good. Go out there and find out. You can always get a recess. If you got to go to the bathroom, anything, you can get out there and find out what's going on and find out who's out there and who's not. Now, I'm sure you're all familiar. If we talk about the case law, I generally don't talk much about case law, but the new case is Batson versus Kentucky. I'm sure you've all become aware of that case, and I think that the policy that we should all take in that case is that, and your unit chiefs, I guess, will tell you when you get to that level, but I think the policy that we have been using is that, if for you who's not familiar with it, that's a case in which a guy was convicted of rape, I think, down in Kentucky, and he was tried by an all-white jury, and the prosecutor had struck all blacks, and and it was a racial case, and under those circumstances, they ruled that that was not due process under those circumstances. But again, you have to read Batson. It's very limited to the facts of that particular case, because you had a racial case, prosecutor struck all blacks. There was every black on the panel. In other words, there were 6 on the panel, and he struck all 6. And that often isn't the case here. But in the future, we're going to have to be aware of this case, and the best way to avoid any problems with it is to protect yourself. And my advice would be in that situation is, when you do have a black juror, you question them at length, and on this little sheet that you have, mark something down that you can articulate later time if something happens. Because the way the case is stated, that it's only after a prima facie showing that you're doing this that it becomes that the trial judge can then order you to then start showing why you're striking them, not on racial basis. So if you do, let's say you strike 3 blacks to start with, the first 3 people, and then it's like the defense attorney makes an objection saying that you're striking blacks. Well, you're not going to be able to go back and say, oh, yeah, make something up about why he did it. Write it down right then and there. I'd write it right in my little box there, you know, and question him and say, well, the woman had a kid about the same age as the defendant, and I thought she'd be sympathetic to him, or she's unemployed, and I just don't like unemployed people because I find they're not too stable. Any of those reasons, have them marked down in those situations, so that if the judge does come to you and say, what about it, McMahon? You could say, Judge, this is my reasons, and I have them marked down here. If he puts you into that situation. So that's happened to me in the last 2 homicides I've tried, that they brought that objection up, and by marking it down, I've tried to make a record of what my reasons are. So sometimes under that line, you may want to ask more questions of those people, so it gives you more ammunition to make an articulable reason as to why you're striking them and not for race. So that's how to pick a jury.
So there you have it. You can obviously see that race plays a role in the jury selection. And I don't know what year this clip was made, but you can tell clearly that it's an old clip. And if he's been doing it, lawyers and prosecutors before him have probably been doing it as well. And basically, race plays a role. It's probably always going to play a role. It's always going to be one of many dynamics that's going to play into picking a jury and deciding your case. So that's it. Leave your questions, comments below. Do you think that race plays a role in the jury selection? Do you think that it doesn't make a difference? Leave your questions, comments below, and let me know.